I am very glad to be able to be here and speak to you today about automobile issues in the Federal Trade Commission. Well, let me talk about some of the Federal Trade Commission's ongoing work to protect consumers and educate dealers in the auto marketplace. We've enjoyed a very constructive, decades-old partnership with NIADA that has helped dealers understand how to comply with the law and how to and how we enforce the consumer protection laws that we are responsible for. A really good example of this is just yesterday with NIADA significant assistance. The Commission released a detailed set of frequently asked questions and answers for auto dealers about the recently amended used car rule. This morning we were distributing the FAQ to about 65,000 people who subscribe to our FTC blog. And so I think that's a really good example of how the FTC and NIADA have continued to work very constructively on issues of common interest, and I hope that that's something that would be a very good model for us as we move forward. Well, one thing I have to note before I go further with my remarks is that the remarks I give today are my own and do not necessarily represent the views of the Commission or any individual commissioner. This morning I plan to talk about three main things. First, I will discuss the FTC's general approach and priorities under Acting Chairman Maureen Olhausen. Second, I will discuss our recent work in the auto marketplace, including our law enforcement work, guidance, and some of our policy issues. And third, I will try to give you a very short description of things that I think are on the agenda at the FTC for the coming year that would be of interest to auto dealers. Let me start off by talking about the FTC's overall approach and priorities, which I think is a marked contrast under our new Chairman Olhausen compared to prior Chairman Ramirez. Since taking lead of the agency in January, Acting Chairman Olhausen has adopted what she calls a positive consumer protection agenda. You know, both Acting Chairman Olhausen and I are advocates of free market, less regulatory approaches. Yet at the same time, we also know that we are running a law enforcement agency. And so we do also have to be committed to using the law enforcement power that we have to protect consumers and to protect competition in the marketplace. Especially, we're trying to protect competition in the marketplace for a lot of small businesses, because we do realize that small businesses are a source of great economic growth in the United States. So a lot of our law enforcement activity, while in one sense is very focused on protecting consumers, it also is designed to make sure that competition can occur in the marketplace without deceptive claims that can distort competition amongst firms. One thing that we are providing is, as part of this positive consumer protection agenda, is really focused more on finding ways that we can provide more guidance upfront to industry about what standards are. One of the things that is most unfortunate is when you have companies that, in fact, truly in good faith want to comply with the law, but find that it is too difficult, complicated, or unclear as to what they should do. And we firmly believe that that's not in anyone's interest to have cases that we bring, cases and investigations that auto dealers and others defend, if the real reason why the problem exists is just a lack of certainty as to what the standards are that we could have cleared up front. And so one of the things that we are trying very hard to do is to try to find topics, areas, issues where through engaging with industry and putting out more guidance documents, we can make it easier for people to comply with the law and save both industry costs and save costs to ourselves. The final thing we're really working to do as part of an overall approach to consumer protection is working to reduce unnecessary and undue burdens on industry associated with investigations, regulations, and orders. For example, last July, one of the things that folks in my shop did is we have completely modified and overhauled our process for civil investigative demands to try to streamline them so they're less burdensome for businesses who receive them, make them shorter in duration so that it's less costly for people to respond to them. But the thing we're trying to do as well is also trying to make our process more transparent. We're trying to find ways that when we send out civil investigative demands in our investigations, the companies have a much clearer idea of why we're investigating, what information we're seeking, and really have a much better idea of what the process is like, so it's a little less daunting to be on the other side from the federal government law enforcement agency. In particular, one of the things that we have done is put on our website FAQs as to what our process is like if you get a civil investigative demand as part of an investigation, so that small businesses, especially those who may not be represented by counsel, can get a much better idea of what the FTC is doing and why, because I think a lot of people are quite mystified when all of a sudden you receive from the agency a civil investigative demand, which is a very a long, complicated legal document, and if you're not a lawyer, you're probably likely to be a little intimidated and put off by that. So we're trying to find ways of conveying in straightforward lay terms what we are trying to do in our investigations, what the process is like, to try to see if we can make progress in making it easier for everyone. So let me talk more specifically about some of our recent work in the automobile industry. We have a long history of protecting consumers and educating businesses in the auto marketplace. As you know, we have very broad legal authority under the FTC Act and a variety of other important statutes and rules that relate to automobiles. And we act as the primary federal law enforcement agency for many dealers. And this is something where, under the Dodd-Frank Act in 2010, Congress was very clear that they wanted the FTC to play a more pronounced, greater role with regard to auto dealers. And I think since 2010, the FTC has taken that to heart and has spent more time and focus on issues related to automobiles than it probably had done in prior years. And so it is definitely an area that the agency views as a priority for its law enforcement guidance and policy type work. The other reason, of course, is, aside from how our statutes are structured and our authority, the other reason why it's important, of course, as all of you know, automobile acquisition is incredibly important to most consumers. Aside from their homes, it's usually one of the largest financial transactions that they engage in, and for that reason, it's a great priority for us as we protect consumers to make sure that they are treated appropriately when they engage in those sort of transactions. The FTC is fundamentally a law enforcement agency, not a regulatory agency. In the last 4 years, we have brought dozens of actions against auto dealers and others in the auto marketplace for conduct alleged to violate the FTC Act and other important laws. Our actions are rooted in decades-old consumer protection principles that we are just applying to new contexts, to new entities. And so there's a long track record that we are relying on in much of our work. The most fundamental principle that comes out in our law enforcement work, probably shouldn't surprise any of you at all, is that dealers must make truthful, non-misleading statements in their advertising to consumers. When they claim when companies fail to do so, they harm not only consumers, but also competitors who are complying with the law, who find it very difficult to get their messages out in the face of the deception being disseminated by others. So for that reason, the agency has taken a variety of actions to stop dealers from making deceptive claims about important aspects of auto transactions. Indeed, as I have seen in my recent review of a lot of our auto work, challenging deceptive claims makes up the largest part of the FTC's case law involving auto dealers. For example, the FTC has brought a number of recent cases against dealers for making deceptive claims that consumers could purchase, finance, or lease cars for attractive terms that prove to be illusory, like very low prices, low down payments, low interest rates, things like that. These types of claims are at the root of many of the actions that the FTC took in two large national enforcement sweeps, the Operation Ruse Control in 2015 and Operation Steer Clear in 2014. In these cases, we allege that dealers often buried the true terms of their offers, like large hidden fees or other important restrictions, in fine print. As we charged in these and other cases, such conduct violates Section 5 of the FTC Act, and in many cases, other laws like the Truth in Lending Act and the Consumer Leasing Act. Another example involves claims that were made about deals that are not available typically to consumers. For example, we've asked dealers to stop touting attractive prices, discounts, or other terms that are simply unavailable to the typical consumer who is receiving ads. For example, in last year's Progressive Chevrolet case the FTC brought, the Commission issued an order against auto dealers who advertised attractive lease terms like zero down, when in fact fewer than 20% of the consumers actually would qualify for these terms based upon their credit scores. The dealers in this case allegedly buried this important restriction in confusing fine print that consumers were unlikely to notice or understand, and thus they violated the FTC Act. And so the order in this case against Progressive Chevrolet prohibits the promotion of attractive terms without clearly and conspicuously disclosing qualifications or restrictions on the consumer's ability to obtain those terms, including if a majority of consumers are likely to meet applicable credit score requirements. Let me give you another example of a category of claims that the FTC has been very active on in challenging as being deceptive, and those involve add-on products. The Commission has pursued deceptive practices associated with marketing of add-ons like payment programs, extended warranties, or gap insurance offered to consumers by dealers' F&I departments after they've selected a car. In 2015, for example, we brought an action that charged the Matt Blatt dealership with touting during in-person solicitations that a biweekly payment plan would save consumers money, while failing to disclose that in many instances, consumers were charged hundreds of dollars in fees and ended up actually paying more under the plan. Cases like Matt Blatt also highlight the FTC's protection against deception extend beyond what you would think of as traditional advertising claims that appear in TV, radio, and print. It includes representations dealers and other employees make to consumers when they visit their lots in person. One other big area of FTC enforcement in the last couple of years has involved deceptive claims involving auto recalls. The agency brought complaints against General Motors and 5 dealers alleging they violated the FTC Act by touting the rigor of their used car inspections. However, they failed to disclose that some of these cars were subject to unrepaired safety recalls. The agency's orders in these cases, among other things, require these companies to qualify their inspection claims with clear and conspicuous disclosures regarding the existence of the recalls. One more category that I will mention, and as I indicated, many of our law enforcement cases do arise in the context of deception. And the last set of category of deceptive claims that the FTC has been very active in challenging involve deceptive environmental claims, in particular a case involving Volkswagen. In this case, we allege that Volkswagen deceptively touted its clean diesel cars as environmentally friendly. It's environmentally friendly, even though Volkswagen had fitted such cars with illegal defeat devices designed to mask high emissions. In settlements with the FTC and other law enforcers, the company agreed to pay up to $11 billion to compensate consumers. As we've been publicizing in our business and consumer education materials, affected consumers may be eligible for an all-cash buyback of their vehicles with the possibility of technical modifications to their cars. And we'd encourage you to ask consumers to check the eligibility of their cars at vwcourtsettlement.com if you have cars that may be subject to this order. The FTC has also been cautioning dealers to avoid making misleading claims concerning this case. For example, we've seen some promotional offers that seem to be making the false implications that they are associated with the Volkswagen settlement. Okay, well, a lot of what we do at the FTC in looking at the auto industry from our law enforcement perspective involves deception, but it's not limited to deception. For example, the FTC is continuing to do a lot of work with regard to data security and privacy, and we have found some of those issues are also impacting auto dealers. One good example involves some work under the Fair Credit Reporting Act. For example, in 2015, we filed a case involving Tricolor Auto Group in which we alleged that the loan servicing arm of an auto dealer violated the FCRA's furnisher rule. Specifically, we charged that the company had failed to have written policies and procedures regarding the accuracy of the information that they reported onto credit bureaus, and that they failed to properly investigate disputes that they received directly from consumers. The order in that case required the auto dealers to pay over $82,000 in civil penalties and prohibits the dealers from future violations of the furnisher rule. Some of our cases also emphasize that auto dealers, like other companies that handle consumers' sensitive personal information, really need to be vigilant about data security. The FTC has brought roughly 60 cases against companies that engage in unfair, deceptive acts or practices that put consumers' personal data at risk. Among these cases, when actioned in 2012, we took against an auto dealer, Franklin Budget Car Sales, for its alleged failure to employ reasonable security measures to protect consumers' sensitive information. In all of these cases involving data security, what's critical is the concept of what are reasonable measures to protect data. And that's something where we recognize that inherently there's uncertainty about what is a reasonable procedure and what is not. And so we have, as I'll talk about in a moment, spent a lot of time and effort since I started my job trying to get out and trying to engage with the small business community to give them a better idea of what kind of data security measures they should have in place to protect the data that they have. Well, having spent some time talking about our law enforcement work, and that is most of what we do at the FTC, let me now turn to our significant education and outreach efforts. While the FTC primarily does law enforcement, we really believe that education and outreach are helpful both to consumers and businesses, particularly small businesses, so that everyone can understand the law and make it easier for everyone to operate in this space. We've created a variety of business guidance and other educational materials for auto dealers to try to help with some of these efforts. We've also hosted some public workshops on emerging trends and other consumer protection issues in the auto marketplace. I'm going to talk about each of those a little bit as well. Let me start with our large suite of business guidance and educational materials. I think probably as the most important one, or at least the most recent one, as mentioned earlier, just yesterday, we had issued a FAQs for complying with the admitted used car rule. That document was the product of a lot of very good cooperation and collaboration between the staff that work for me and NIADA to figure out what questions are most important to the industry, how can we answer them in a way that industry will understand them, and I'm glad that we were able to get that document released in time for this conference this week. But first, let me talk a little bit about the used car rule. As you know, generally the used car rule requires that dealers display a buyer's window guide sticker on vehicles, providing warranty and other important information. In late 2016, the FTC issued amendments to the rule requiring disclosures of more information and to make it easier for dealers to disclose warranties. Among other things, the amended buyer's guide sticker will recommend that consumers get a vehicle history report before buying a car and direct them to the Department of Transportation's safercar.gov website for information about safety recalls. The amended rule also clarifies the meaning of as-is sales and adds boxes that dealers can check to disclose third-party warranties, available service contracts, and unexpired manufacturer warranty. Further, the guides will direct Spanish-speaking consumers to ask for a copy in Spanish if the dealer is conducting the sale in Spanish. So the idea is that these new FAQs are designed to help dealers understand and use the updated buyer's guide. As many of you know, we've got a January 28th, 2018 deadline for having all used buyer guides transformed over to the new ones. And so the idea would be that issuing these FAQs now should be helpful as people go through the last steps of making sure that they have new buyer's guides that will be compliant as of this coming January. So we're very grateful for NIADA's help in coming up with that guidance piece because I think it will be helpful to all of us. Let me talk about a couple other important business guidances for dealers. We have a library of educational pieces that are available for auto dealers on our website. We maintain a website portal dedicated specifically to dealers with guidance on everything from online disclosures to business computer security. Just go to our website, ftc.gov, and click on Tips and Advice. Go into Business Center, and then there's another tab that says Other Industries. You can click on that, and you can click on the Auto Industry tab. Among other useful materials, this dealer portal includes our advertising FAQs for small businesses, which goes through the analysis that we usually go through in looking at particular ads to decide whether or not we think that they may be deceptive and worth investigating and pursuing. The portal also includes a very popular .com disclosures publication, which is really extremely valuable in trying to figure out if you're going to add disclosures, how to do them clearly and conspicuously enough so that consumers can understand them, can appreciate them, and that can modify the way they view ads, especially because, as you may have noticed in many of the cases that I was describing that arise out of the deception context, a great many of them involve the failure to disclose information well enough to consumers so they can understand it. So definitely, if you are including in ads or the communications restrictions, limitations, conditions on offers that are being made, certainly would suggest looking at the .com disclosure document because it gives you a good idea of what you will have to do to make those kind of limitations and conditions sufficiently apparent to consumers so they can understand them and you can avoid liability. Also, I'd just note that we have prepared 80 different business blogs, blog posts with information about auto dealers. You can subscribe to these blogs, or you can just find them in the business blog section of our website. So a lot of material available there. One thing that I have mentioned earlier that is a big new initiative for us is looking at data security issues and trying to figure out better ways of doing our guidance. Historically, the way we did guidance about data security issues is essentially we put out information about the cases that we had brought, which does provide a good example for businesses about what they should not do. But what they didn't really realize is that there's a large proportion of cases that we open and we decide to close because we decide that the companies had done an adequate job of protecting security, and yet that information never really was getting out to the public. So one of the things that we are trying to do is we are going through key concepts in data security, and we are trying to provide more information from a FTC level as to when our staff has investigated particular issues and decided that it really wasn't worthwhile proceeding, see if we can tell businesses more about that so they would know what to do right, not just what not to do. The other thing that we are doing to try to make this business education effort more effective is we are having meetings throughout the country where we are engaging with small businesses to ask people, what do you actually really need to know about data security? What are the questions you have so we can try to answer the most relevant questions small businesses really need answered to comply with the law? I mean, one of the hardest things that I think happens when you become official in Washington, you think you know what people really need to know in other parts of the country, and you want to just disseminate the information out there to them. And I think we're trying to be more reflective about what people don't know, what they do need to know, and how we can actually provide them with the information that's most useful to them in making their decisions. I would mention one last source of information, and that's we have a senior attorney, Leslie Fair, who writes a monthly column for Used Car Dealer magazine. Leslie's very colorful and very experienced in FTC law, so if any of you have a chance to read her articles, I definitely would encourage you to do that. She's told me that her next piece is going to be about the used car rule, buyer's guides, and the FAQs and the like. And so it may be a very, very timely topic for those of you who are preparing to come into compliance in January. Last thing I want to talk about part of what the FTC does with regard to auto dealers that may be of interest is really a lot of our outreach and public workshops. One of the things that the FTC historically has tried to do is, unlike some other agencies, when a new problem, new issue, new concern comes up, we try to study it first before we start to bring law enforcement action, before we try to engage in rulemaking or other measures. And that's a lot of what you see is that when we're confronted with new or challenging issues, what we will do is have a workshop where we bring in consumers, academics, industry, government folks, and sort of hear what the issues are, what people are thinking about, to make sure that at least we have a good sense of what the issues are before we start wading in and starting to make policy cuts that could have unintended consequences and therefore be quite harmful, and we certainly don't want to do that. We've undertaken a couple of these public workshops with regard to auto issues recently. One of these involves the Connected Cars workshop. In June, the FTC and the NHTSA co-hosted a public workshop on connected cars. As you know, cars are increasingly becoming equipped with technologies that enable them to connect to the internet and use data for entertainment, performance, safety purposes, and the like. These technologies, like the others the FTC examines, present significant potential risks and benefits to consumers. So we're really trying to get a handle on what these risks are. We made a point of partnering with NHTSA to do this workshop because all of the safety issues with regard to cars are much more within NHTSA's bailiwick. But we have a long history of looking at privacy and data security issues. And as you get cars connected to the internet, you have much more data that is being preserved, flowing, being stored. And so we wanted to make sure that we had a better understanding of how connected cars work and what its data security and privacy implications would be for that. So we did a workshop this last summer, heard from industry, heard from consumer advocates, heard from academics about issues related to connected cars. And so I think you will see a lot more developments related to connected cars in the future. And with the FTC, our focus is not likely to be on the safety aspects of them, but it's going to be far more likely to be focused on data security and privacy about a lot of the information that is collected and used as part of the operation of connected cars. The other area that I think that we have been doing a lot of outreach and public workshops is to try to get out to some members of the public that really probably did not receive as much attention from the FTC as was warranted in the past. I think one of them is the small business community, which I think a lot of our business guidance activity is designed to engage with them, but there's some other parts of the population, like military consumers, rural consumers, who I think that really have not received as much attention with their consumer protection problems as was warranted. And so we've been doing a number of workshops going out and talking to military consumers and rural consumers about what sort of consumer protection problems they have and what we can do to help. Well, this past July, we held a workshop in San Antonio, Texas, to look at financial issues and fraud affecting military consumers, including service members and veterans. The workshop's first panel focused on how auto purchasing, financing, and leasing affect the military community. We had a panel where experts discussed how deployment and returning from deployment can affect service members' auto transactions. Panelists also discussed military consumers' experience with negative equity and add-on products and services, particularly given how the extraordinary sacrifices are made by a lot of military members and their families. We really are trying to make sure that we do our part and make sure they're protected from problematic practices when they're here at home. It's one thing that industry was very helpful to us in understanding a lot of the special situations that come up about automobile transactions that relate to members of the military, given their particular circumstances, and that was very useful. Well, finally, let me give you a few ideas as to where the FTC may be going with regard to auto dealer issues in the near future. Auto deals will continue to be a focus of FTC law enforcement scrutiny. I think that, as I mentioned earlier, some of that is because Congress has indicated they really want us to play that role. The other, of course, is that auto purchases and leases are incredibly important financial transactions for most consumers, so we really want to make sure they're protected, as well as making sure that competition in that marketplace can occur in the absence of deception. I think a lot of our focus is going to continue to be on deception. It's going to continue to look at claims that are made to populations like military consumers, rural consumers, that we really have decided that we want to focus on increasingly in their protection. We're also going to be looking for instances where we have information that shows that the claims being made has caused real harm to consumers, especially financial harm. A lot of cases that is going to be based upon consumer complaints that we see about the practices of dealerships, although whether complaints are available is highly variable depending upon what kind of claims are made, what kind of dealerships you have, et cetera. But we really are looking for solid information, if we can find it, that a deceptive claim was made to consumers and that consumers were adversely affected, to make sure that it's worth our time and effort to pursue that kind of a case. And so I would highly recommend, since we are going to continue to be very active from a law enforcement perspective and looking at what auto dealers are doing, I'd recommend very highly focusing on being extremely careful in part of your compliance, especially advertising compliance work. I would suggest, too, if you have questions about how to convey claims, how to convey information, go to the FTC website, look at some of those materials there to see if you can get some ideas about how to do it right, because it is something where we are very actively monitoring the marketplace. We're very actively monitoring the complaints we get in from consumers, and we are looking at that kind of information and deciding what kind of investigations to open and what kind of cases to pursue. As I mentioned earlier, one of the biggest problems that we have seen with auto dealer ads tend to arise with the failure to disclose restrictions, limitations, conditions, and offers in a way that consumers understand them. So that's something, too, that I would suggest people be very cognizant of, is that if you are going to impose limitations, that you disclose them in such a way that consumers will understand and appreciate what those limitations are. One of the things I would emphasize is that it is unlikely that the FTC is going to start any rulemaking with regard to auto dealers. We're very much a law enforcement agency. That's our focus. We think that we are doing an effective job in dealing with the problems in the marketplace through our combination of law enforcement, guidance, policy work. Personally, speaking just for myself, I don't see any particular reason to do rulemaking right now with regard to auto issues. And so I would be very surprised if the agency would do that. I think what you're going to continue to see is case-by-case law enforcement. You're going to see more and more guidance activities by the agency just to try to get information out there about what the current standards actually are, what they mean, how to comply with them. And I think that's a very good place where the FTC can work together very constructively with NIADA and others to try to figure out what messages do we need to get out? What are the issues that people don't understand? And how can we get out guidance materials so that people can come into compliance and therefore people can avoid unnecessary investigations and prosecutions, which of course saves the dealers time and money, and it saves us at the FTC time and money too. So I think there's a great opportunity for us to continue to work on guidance materials, and I think it's beneficial to all. I guess in conclusion, I am thrilled that I had an opportunity to come in and speak here today. I'm sorry for my strained voice, but I definitely look forward to continuing to work with NIADA and issues as they come up in the future. And my door is open if people want to come in and tell me about things that are going on that concern them, things that they'd like us to work on that we're not working on. I have 400 people that work for me, and auto is one of the most important things I do, but there are many other things, and so I'm always open to hearing from people that there's some other topic that we really need to address to make sure that consumers are protected and that the marketplace is functioning properly. Thank you very much.
Yes, in light of the recent Equifax breach, the data breach, do you have any insight or guidance that you can give us that we can share with consumers regarding their issues and concerns over the issue?
Yes, a couple thoughts. One, just for the record, I am recused from the FTC has announced publicly it is investigating Equifax. I'm recused from that investigation because Equifax is a former client of mine. That being said, if any of consumers come to you with concerns about Equifax, send them directly to our website, because we have a particular part of our website that has instructions as to exactly what consumers should do if they're concerned that their information may have been accessed through the breach. I mean, it's probably, my guess is you probably are going to get a lot of questions about these because, at least from the press sources, I believe it's 143 million Americans had their information accessed, and so you will get a lot of questions about that. Send them directly to our website because they have their sources and ideas for them, and then that will be probably the best thing because it will answer all of their questions, and it also links them to folks at the FTC who can answer more specific questions about, for example, ID theft reports and the like.
When you're talking about the buyer's guide and the requirement for a Spanish buyer's guide, I understood you to say that if the transaction is conducted in Spanish, but what's the definition for that? Does that mean everything was done? Does that mean you have a salesperson who speaks Spanish, who maybe did the demo ride, and everything else is, what's the break point? What's the real trigger there?
Yeah, I mean, I think what I would, what's the legal standard, I think is not specifically outlined. I guess what I would say is, you know, if you see a consumer and you say hola and then you continue the rest of the transaction in English, obviously I think that's something I would describe as an English language transaction. What I would describe it is when you're talking about the substantive parts of the transaction that really are the central characteristics of the transaction. You know, once you're talking about price, or you're talking about payment terms or interest rates, when you're talking about those things, if you're talking about those types of items in Spanish, that's the sort of thing that to me makes it into a Spanish language transaction where people should be steered to the idea that you should ask for a Spanish language version of the guide. I mean, another way of perhaps thinking about this is that if you are talking to consumers about the type of information that you would see on a buyer's guide in Spanish, you should be sending them to at that point, you shouldn't let them know that they have the right to a Spanish language version of the guide. But if it's something like isolated, occasional, you know, as I say, just you're saying hello in Spanish, that's not enough to do it.
Tom, thank you for your time this morning and for this great information. My question is regarding the Equifax circumstance, and certainly it is unprecedented. This is 1 in 2 Americans that are possibly affected by this unbelievable breach of security. In your experience with the FTC and understanding that this is unprecedented, how is the FTC going to react to this? What do you think are some of our solutions, and how do we stop this from happening again?
It's a very good question. In fact, well, the way the FTC is going to pursue it is primarily as a law enforcement matter. Companies in the first instance have an obligation to take reasonable steps to protect the data security of the information that they hold. And the FTC has an ongoing investigation of Equifax to get at that issue and decide whether what they did or did not do was reasonable. I mean, one thing I would say, I just want to emphasize to people, is that a reasonable standard does mean that you can do all the reasonable things, you can act you can be reasonable, you can take reasonable steps, and a breach can happen anyway. So just because there's a breach doesn't mean you're liable. It's really about what sort of efforts you put into to try to protect the data. And of course, you know, when we look at what's reasonable, it depends upon how sensitive the information is, how harmful it is to consumers if it's released, how large the organization is that's holding the data, how sophisticated they are. You start looking at all of those sorts of consideration and trying to figure out whether they violated the law or not. But that's all kind of retrospective, looking back at, did Equifax or another company that had a breach, did they do what they should have done? I think going forward, a lot of this is trying to get more and more information out about what data security standards are and what people should be doing to protect data security. I think that that's a challenge. Interestingly enough, what concerns me more is less Equifax than, not that Equifax isn't a big problem, but our larger concern with data security had been not so much really large companies and institutions, the data security that they provide, because most of them, if you get to a certain critical mass of size, you have the sophistication, you have the financial wherewithal to hire experts to try to protect your data. I mean, if you're a bank, you're a credit reporting agency, you really do have incredibly powerful incentives to protect your data, and you have the wherewithal usually to do it. I mean, what's always been more of a concern for us is what you do with medium, smaller sized businesses who don't have that sophistication, don't have that financial wherewithal. And a lot of them, at the same time, though, do have very sensitive information about people that they are holding in their files. And so a lot of our guidance activity, a lot of our work has been focused on trying to reach out to smaller entities to say, here are some things that we think that you need to do to protect data, because we were worried that that was a larger risk because the folks were less sophisticated and less financially capable of doing a lot of it on their own. But as the Equifax example shows, even a very large, sophisticated company can have this kind of a problem. So it's a lot of education, getting information out there. There's no perfect security system. That's part of the challenge too. Is that it's this incredible effect where the hackers will find one technique to get in, and so you develop a solution for that, so they try to develop the next technique to get in, and you have to develop a solution for that. And so you have this continual process where you have to keep updating your security, and you have to keep updating your techniques to defeat hackers over time. And so it is a very hard and expensive process. I wish there was a magic bullet that, if you did security program X, all would be well, but it's not the case. So from the short-term perspective, going retrospectively, we're going to see if there was something that happened at Equifax as a law violation, and if so, what the FTC would do about it. But more generally, to me, it really kind of underscores the importance of getting out information about data security to everybody.
All right, good morning. Thank you for coming in and speaking to our group. I appreciate it, especially since it looks like you're not feeling too well up there.
Thank you.
But thank you. I'm from California, and our state association has seen a really large increase in illegal online sales, specifically individuals that are selling large quantity of vehicles. Many of these vehicles have salvage titles or flood vehicles, rollback odometers. Our association has filled out online complaints to the FTC regarding this, but we haven't heard back. This really hurts, as dealers, this really hurts us. We spend a lot of money on running our businesses and complying with the law, bonds, licenses, insurance, the whole thing. Yet you have these individuals that are selling large quantities and getting away with it. Is there a different way we might be able to approach the FTC as a state organization to see if we might be able to crack down on these individuals?
I think you just did what you should do. Having filed the complaints, that's great. Having told me, I was not aware that some of those types of complaints had come in. I will talk to our Division of Financial Practices and make sure that they have seen those complaints and ask them about them. As I was mentioning earlier, one of the reasons why we feel so strongly about keeping deceptive claims out of the marketplace is because of the effect it has on competitors. And certainly if other folks can be offering products that have flaws or problems and they're not disclosing them, that puts legitimate, honest dealers at a disadvantage. And so we do recognize the value of making sure that that kind of conduct in the marketplace is addressed. So I will talk to the folks who work in the Division of Financial Practices about it. The other thing that I would always encourage folks to do is to complain to the state AGs, other state officials too, because they bring a lot of auto cases, a lot of auto matters, and so the more enforcers you can have taking a look at it or thinking about it, the better. But I will follow up with the folks who work in financial practices.
Yeah, we have a good relationship with our state Department of Motor Vehicles. They're just so overwhelmed with the large amount. We started reaching out to the FTC to see if they can do something as well, because these are unlicensed dealers. They're dealers. They are not dealers. They're just individuals that are taking advantage of consumers.
Okay,
I appreciate it. Thank you.
You know, a lot of what we do at the federal level, and some of my colleagues, former colleagues from the CFPB are here today. At the federal level, when we bring investigations, we in the CFPB, assuming that there's a matter that we have concurrent jurisdiction over, so either one of us could investigate, we have essentially a system where each of us notifies the other once we open an investigation. So one of the things, and then typically the other agency doesn't investigate. So we do have a process in place where we in the CFPB, essentially it's like first to file or first to put your marker down on a company as someone you're interested in looking at, typically indicates to the other agency that matter is being handled. There's no reason for them to act. And of course, obviously, the reason why we're doing that is so we don't duplicate efforts, but also to avoid the possibility that people might end up being investigated by two federal agencies at the same time, which is, of course, at least twice as bad as being investigated by one federal agency. So we do, on law enforcement activities, we do talk from time to time about with the CFPB about where each of us are going and issues that relate to auto. But when it comes down to individual investigations and what we open and don't open, we have a process in place to make sure that we coordinate and don't duplicate our efforts. Most of the rulemaking activity that this CFPB does that could relate to auto dealers, the FTC is entitled to get notice from the CFPB when they're coming forward with their rulemakings and what they're thinking about doing. We have a long tradition at the FTC of filing advocacy comments with our own thoughts about other agencies' policies that are reflected in their rules, whether they're good for consumers, whether they're good for competition. And so if the CFPB is going forward with any rulemaking activity, we would be notified of that and have an opportunity to weigh in with our perspectives before the agency goes forward. With regard to the states, a lot of what we end up doing with the states is the federal government, the FTC and the states each essentially are sovereigns, and so we do our own investigations. That being said, once we start getting a critical mass of investigations on a particular topic in a particular area, we tend to reach out to the state attorney generals to see if they are doing something similar or not. And again, a lot of it is we're trying to duplicate efforts. To avoid duplicating efforts, we're trying to figure out ways to coordinate with states. Sometimes we will put together sweeps where states have cases that deal with the same topic as the federal government, and we'll announce them all at the same time. States, it's highly variable how much they coordinate with the FTC, what their view of the world and cases are. As you can imagine, there are 50 attorney general's offices in the United States, and they run the ideological and partisan spectrum and how much they want to cooperate, they don't want to cooperate with us. And so how closely we can work with them depends a lot on which AG's office you're talking about. That being said, I think we generally view them as reliable law enforcement partners, where most of what we're trying to do is, again, avoid unnecessary duplication in efforts And also, too, if they are seeing something similar to what we're seeing and they're thinking about bringing cases, try to figure out if there's a way that we can act together that will maximize the impact of both of our work.